See the evidence log?
Yes.
So the evidence log itself will not be in this packet, no.
So the volume is going up as high as I can get it. I apologize for disturbing
Could you briefly, start here, but I'm gonna go back. But with reference to the evidence log, what is that exactly? What is, could you kind of explain to the jury what is function of an evidence log?
Yeah, basically, an evidence log is just a document that it documents what evidence is discovered and what evidence is collected, date, time, who recovered it, and so on.
Would it also give you an indication in terms of which officers were at a particular scene?
It could, yes.
When you have, say, crime scene, a crime scene normally take off, say, evidence tape to tape off a crime scene. Is that normal procedure?
Yes, it is.
In say, for instance, in a case where you're, say, seeing that subject like a search warrant or something like that, would you want to put evidence tape around a particular scene?
Yes, sir, you'd want to secure that scene. That's correct.
Okay.
Well, that's
Now,
working.
was that done in this case?
Yes, it was.
Okay. Do you recall which, which officer, say in the Fowler location?
I'm sorry, Mr. Cox, can you
The
speak?
Fowler location, do you recall which officer would have been responsible for placing crime scene tape?
No, sir, I don't recall.
If once that crime scene tape is established, if a person goes into that scene, would that person have to be listed on the crime scene log?
That person should be listed on the crime scene log, yes, sir.
And which would also should indicate when that person entered the crime scene and also when that person exited the crime scene, correct?
That's what should happen, yes, sir.
With reference to crime scene log in this case, that you said it's not a part of your safety exhibit number 11.
No, sir.
Did you review that information in preparation for your testimony?
Yeah, you're asking about the crime scene log?
Did you look at it? Did you review it?
No, sir. No, sir.
So there were some items referenced this case, your testimony that you didn't review before in preparation for your testimony.
That's correct.
Finally, the crime scene log in this case, do you know whether it was 1 page, 2 pages, 3 pages? Do you know?
I couldn't tell you, no, sir.
If you, with reference to state's exhibit number 11, if you look through it, could that refresh your recollection to how many pages compose the crime scene log in this case?
I don't believe it would. No, sir.
You didn't put it down. You didn't write it down in there anywhere?
No, sir.
Now, this particular case was actually assigned to you, correct? In terms of an investigation, eventually this case was assigned to you, correct?
Correct.
Okay. And you testified earlier, you're a Texas Ranger, correct?
Correct.
And when a case is assigned to you, you become like the primary or the lead law enforcement officer with reference to as pertaining to this case, correct?
Correct.
So it's fair to say that in terms of information as situations develop, even if you get information with reference to work from other officers or other rangers, it's fair to say that that information eventually flows to you, right?
It should, yes,
It
sir.
should. And it's fair to say, is it fair to say that one of your jobs would be to compile all the evidence in the case, correct?
Correct.
And that becomes, I would say, a master file for you, and all the information that has been collected from this case. You should have the ability to access that information. You are basically responsible, correct?
That's correct.
And it's fair to say that if, say, for instance, if there was, say, additional information that was needed, say, for a witness to be contacted or to look for, say, additional evidence, if you were not able to do it yourself, you could actually request other rangers or other law enforcement agencies to assist you, right?
That's correct.
Yo, I have him at
Yeah.
1.5. That is how slow he is.
Do you recall when you first became involved in this case in terms of the approximate date? When did that happen?
That was in May of 2021.
And was the case assigned to you by someone? Is there a procedure how you would be the lead on a case, not someone else? How's that work?
So I wasn't really assigned the case, if you will. The case was brought to me is how I became the lead on that investigation.
When you say brought to you by another ranger or another police agency?
Right. So as we discussed yesterday, the information in reference to missing person, the possible murder, was brought to me by Special Agent Nava with EPS.
Now, once that occurred in this case, it would be the first thing to do is to try to develop in terms of either a strategy, or do you just at that point try to review information and make a determination in terms of how you're going to say attack or address trying to resolve the case? How that?
So it depends on a case-by-case basis. In this situation, there was an individual that was a witness that was interviewed that provided the initial information to start that investigation.
So it started out in this case with the interview process of you with witness.
Correct.
Okay. Now, do you recall the reference to that first witness? Is it someone that you interviewed yourself, or was that person interviewed by another officer?
So myself and Agent Nava interviewed the initial witness.
Good morning, Miss Running.
And just to be clear, Nava isn't actually he's DPS, he's not a ranger, correct?
He's not a Texas Ranger. He's assigned to the Criminal Investigations Division.
How are you, beloved?
Did you have a partner, or did you join with someone and have someone join you from a ranger that from the Texas Ranger that became like your assistant in terms of this case?
So at some point, I requested the assistance of Ranger Pettis.
Do you recall that was within the week?
I have
later,
this-
or-
I don't recall, no.
At 2-speed, I believe. 1.5. And he's still slow.
You, as a Texas Ranger, you also you have been certified as a peace officer, correct?
That's correct.
Do you use a body cam? A body cam?
No, sir.
That's something that's not issued to Texas Rangers.
No, sir.
Other agencies, they have them, correct?
Yes, sir.
But is there a reason?
Here's the normal. Ready?
Don't have them?
I don't know if there's a reason. Really, so we're not, as Texas Rangers, we're not out making contact with the public every day. We're not out making traffic stops and making contact with citizens every single day. The majority of the contacts that we have are going to be in interview rooms like y'all have seen, and the majority of those interviews are all on video and audio recorded.
So in terms of the first witness that you contacted in this case, was witness interview on videotape?
Yes, sir, he was.
And that videotape, that video interview was conducted with?
At the Texas Department of Public Safety Regional Headquarters here in San Antonio.
And did you, in terms of all the witnesses that you talked to, with reference to state, were their statements all done on video?
I don't know if all of these statements were taken on video. If they were not recorded on video, then there should be an audio recording of those interviews.
So when you say audio recording, you would have a tape recording.
Correct.
All tapes will be given to the state, correct?
Correct.
Now, as you start developing, I guess, leads in this case, did there come a time when you decided to have not necessarily a conference, but you assembled officers or rangers, law enforcement from different areas? You had kind of like a session where you talk to them, you did a briefing?
Yes, sir.
Okay. Was that on one occasion or more than one occasion?
I believe that was on one occasion.
Now, do you recall when that briefing occurred?
I believe it was on the day that the search warrants were executed.
And that also would have been the day that my client's vehicle was stopped, correct?
Correct.
Now, in reference to that briefing that was given, do you recall how many law enforcement officers or agencies that you notified and requested their presence to?
I don't recall. It was a handful of several agencies.
Will that be reflected in your your report?
No,
Who
sir.
sent the information?
No, there's nothing in the report reference to the operational briefing now.
Do you remember where that briefing was held?
It was at the DPS office in San Antonio.
And obviously that briefing wasn't recorded.
No, sir.
Your notification to agencies or officers with reference to that briefing, was it done by text message? Was it email? How do you notify?
I couldn't tell you. It could have been through text message, could have been through phone calls. I could have notified some agencies. Ranger Pettis could have notified some agencies. I don't recall.
So are you saying that Officer Pettis was a part of the process of notifying agencies?
He could have been. I don't recall.
How many officers attended that session?
I could tell you a lot.
I'm sorry?
A lot.
A lot of them? Was it, you think, more than 10?
Yes.
How long did the session last?
I couldn't tell you that either.
Did you have like an itinerary in terms of the things that you made them aware of? Or you got a list of things that you would be with them?
Yes, so basically it was an operational briefing, right? So we were going to execute these search warrants at different locations. So all these officers are brought up to speed on the case up to that point, let them know what has happened, what we're doing and why they're there. And then they will be given assignments from that point. That's all the briefing was.
Do you recall, say, how many Texas Rangers were at that meeting?
I do not.
Was Ranger Pettis at that meeting?
Ranger Pettis was, yes, sir.
So, meaning your itinerary, in terms of things that you discussed with them, you didn't write any notes with reference to that?
Everything that would have been discussed at the briefing is in the details in my report.
Is that a report part of 1611?
Right. So again, the briefing is not discussed in State's Exhibit number 11, but the details that are in my report, that is what was discussed at the briefing.
Oh, come on, for the love of God.
So at the briefing, did you give any assignments to any of the officers that were the claims that you wanted them to do?
There were things that I wanted them to do that needed to be done. And I don't know if I necessarily, well, I know for a fact I didn't make all of those assignments. They may have been divvied up, and supervisors of deputies or officers that were on scene made those assignments. I don't know how all that happened.
Okay. So you were conducting the the briefing, correct?
Yes.
Do you recall what assignments you made?
I don't recall.
And that's not in your notes either.
No, sir.
I've got to pause this and explain this for those who are just joining us. Thank you for joining your alternate juror. The gentleman, and I use that loosely, sitting here in the end, is the defendant. His attorney here is, I swear, if I put a firecracker under his butt, he's barely going to move. He is slow as molasses. And in this entire trial, he acts like he hasn't even prepared a single question. I have this set at speed at 1.5 advanced, and he's still slow. I just want to don't have one. I need to get a explosion sound, but then that may scare some people. But I want a lot of fire under his butt. The gentleman here, I once again use loosely, is on trial for killing a lady. He walked up to a vehicle, unloaded a weapon, dragged her out of the vehicle lifeless, put him in his car, drove him and her home, dismembered, and put her in the burn barrel and burned her with the trash.
Do you recall whether you
Yeah.
did these assignments?
Yes.
Did you give any officers any assignments as to look for a vehicle, a type of vehicle that was the subject matter of the investigation?
Yes, sir.
And you remember that?
In here.
I remember that there was a specific vehicle that we were looking for, yes.
Do you remember whether you gave any particular assignment to any officers or agencies reference to that particular vehicle?
I don't remember any specific instructions reference that particular
I'm not
vehicle.
showing up, just FYI on the court.
So it's fair to say you remember having a briefing, correct?
Correct.
But as to what actually happened during that briefing, you don't recall it.
No, it was giving the officers that were there that had no knowledge of the case, information on the case, so they knew what they were doing, what they were looking for, and why they were there.
Do you remember ever giving any instructions about a particular vehicle that was supposed to be traveling a certain road and to have that vehicle and to find proper cause to stop it? Ever given any instructions like that?
So I do remember that happening, whether I gave those instructions or somebody else gave those instructions, I don't know.
I just decided to
In your
put my
testimony, there's nothing
on this trial and try out all my new
or anything else that you wrote down,
This is pretty
all
much
that briefing that you could go back to and refresh your recollection of what happened and how it happened.
I can go back and look.
Okay. Do you have that information right now? Look.
State's Exhibit 11, I got it right here.
Oh, look.
Let's see if you can hear this. My little chipmunk. I want to do this to move the guy along. Well, hallelujah, you finally got some rain.
So detail 7.3 mentions the traffic stop of the vehicle.
But does it mention anything about what you said or may have said to officers at the briefing?
No.
I said, I'm finally glad you got some rain. I'm glad you
Yeah.
got some rain finally.
Eventually, he'll say that a client vehicle was
I
stopped,
gotta
right?
just my
Correct.
hearing aid. It's so weird.
Uh,
Can you understand me now? I'm pretty banged up.
Do you recall whether you made, whether you were notified of when that vehicle was located?
At some point, I was notified that it was located.
Do you recall whether you went to the location of where that vehicle was?
I did not.
Do you recall where you were when you got the location of that vehicle was?
I believe I was at the Lucky Road address.
Does it matter? No.
Now, the crime scene log for the Lucky Road. Is that in your packet?
It is not.
Do you remember seeing? Have you ever seen, do you remember reviewing it ever?
It's been a while if I reviewed the crime scene log.
So if it's not in your report, where would it be?
It would be included in the attachments included to my report.
Do you have a copy of those attachments?
I do not have a copy here now.
Where are they located?
They would be included with the file.
Okay. So your master file is where?
So everything that I have was turned over to the prosecutors.
Oh
So where
my
those attachments are,
God,
I
child.
don't know.
And you don't keep copies of them?
Yes, I keep my own copies, yes.
Right. Okay. So where would your copy?
My copies would be stored in my office in Seguin.
I would go on,
So that file.
I would be saying
that you have
objection,
seen,
relevant.
Your testimony that you never went back to review it in preparation for this case.
So I didn't specifically review that crime scene log, no.
And so the file itself, you review it. The file is again, your master file is again. Have you ever reviewed that file in preparation for your trial testimony?
The entire file, no. I reviewed State's Exhibit number 11, the reports that I made reference this case.
Objection, relevance.
So you don't recall whether there is a crime scene log for the Lucky address?
There should be a crime scene log, yes.
Well, he does have questions. He's checking them off.
Now, do you recall ever giving any officer or any ranger instructions in terms of if the subject that we're looking for, my client, if he was, say, arrested, that you wanted an opportunity to question?
I don't recall if that conversation was had. I mean, I'm sure it was because that's what happened, but I don't recall specifically that conversation, no.
So, it reflected in your report the approximate time my client's vehicle was stopped.
Let me take a look.
Did y'all hear the crickets? Here's the bomb ticker.
Again, detail 7.3 report indicates that he was observed driving the Yukon at 5:36 p.m.
I'm trying to play with my sounds. That's the whole point of going ahead and going
And
live today. So if I'm playing
You
with
believe that at that point you were at the Lucky list, correct?
I could have been on the way. I could have been
Yeah,
there
you're
already.
clearly.
I don't know.
Now,
So with him, I want to do cricket.
you indicate that you executed search warrant at that location, correct?
Correct.
Okay. Do you recall what time you arrived at that location?
I don't recall.
Do you recall how long you were at that location?
I do not.
Don't recall it. Do you recall what time you left that location?
I do not.
And none of that is.
Do we call breathing?
I can go back and look and see.
Could you please?
Do you know how to breathe? Do you recall putting your socks on this morning? Do you recall if any cleaning yourself after going to the restroom? I mean, this guy is driving me nuts.
So it had been getting late in the day, closer to dark. Detail 7.12, due to the time of day and limited daylight, it was decided to resume the execution of the search warrants at both properties the following day. So I would assume it was late in the evening sometime.
What, late in the evening is what time? I mean, you know, what
I
time?
could ask 12 different people. They might give you 12 different answers.
Okay. 12 is good. I like to correct me if you can. So you don't know what time you left?
Whatever, I mean, close to dark.
Close to dark. So when you left that address, which, do you remember where you went after?
To the Bear County Sheriff's Office.
Okay, I
Yeah.
want to test something. See if you can hear this. Let
What
me
time
hear
did you
cricket.
get there?
I couldn't tell you that either.
Now, Okay, once you got
Did you hear crickets?
to Bear County Sheriff's Office,
I tried.
did you meet up with other officers, or Ranger Perez, or what did you do?
Met up with other officers there.
You remember who you met?
Ranger Bettis was there, Ranger Wright, maybe Ranger Benoit.
Okay. So at this point.
Tell me if you
when
can hear
arrived here,
crickets.
Do you immediately, do you know that, that my client was at the jail?
Yes, I did.
Okay, you knew he was at.
Yes, sir.
Do you know whether, sorry, you plan, is your plan to try to interview?
Yes.
Okay. Once you go to the jail, do you go and try to interview him?
You're asking that as soon as I got to the jail?
Yes.
No, sir.
And do you have any idea at that point whether or not
Okay, that's what I
waiting
needed.
for you, or not waiting, he being held for you, or whether he started the registration process? Do you know?
I don't believe I know at that point, no.
Do you inquire at the time? Get to the jail, do you inquire as to his status?
I may have, I can tell you one way or the other.
It is not in your notes, not in your report, correct?
Correct.
Okay. Now, so you get to the jail and you meet up with the other officers. You said there was maybe two other rangers that were here?
There could have been, yes.
Could have been any other officers like Bear County or anybody?
Yes, sir, there was some Bear County personnel there.
Okay. And when I say there, in terms of when you have to do a meeting with them, at that point, do you conduct some type of search of the vehicle?
Yes,
Okay, you talk about processing of the vehicle, correct?
yes.
How many officers, rangers, was involved in that process?
Let me refer back to my report.
Oh, let's try it again. I think I know what I did wrong. Okay, let's see. I'm going to try it one more time now.
So Ranger Jesse Bettis, Ranger Kevin Wright, and Ranger Gandhi Benoit, along with Bear County Sheriff's Office crime scene deputies.
Do you hear it now?
Atascosa and Anderson.
So my count is maybe, what, about 8?
So myself, Ranger Wright, Ranger Benoit, and 2 deputies.
Okay, that fixed
So
it.
7,
For 5, 6.
6. Now, so you're just going that you needed 6 people to process that vehicle.
I wouldn't say that we needed 6, but the more you have, the quicker it goes.
So if let's say you bring 14 people.
14 made in a way.
Too many.
Yeah.
So if you say that if it needed, you could have had, say, 4 people involved in the processing of the vehicle, and you would have 2 to go in and interview, if you were able to interview somebody, do the interview, right?
Right. That would be up to the lead investigator, though.
Who's that?
That would be me.
That would be you. So you could make that call. You made
I couldn't make that call, yes, sir.
Okay. You did make that call.
No, sir.
And it's fair to say that you didn't check to see the status of the of my client.
Other than I knew he was at the jail, I don't recall checking on his status, no.
So how long did it take you all to process the vehicle?
I don't recall.
All right, so it's not notated when you started the process, correct?
I can go back and check as well.
And when you go back and check, see if you can determine whether when you arrived at the jail were they in the process of processing of the vehicle, or were they just kind of waiting around you?
Okay.
Go ahead.
So it does not indicate what time we started processing the vehicle, nor does it indicate whether they started, but they hadn't started the processing of the vehicle until we got there.
So you got, when you said we got there or you got there?
I got there.
Okay, you weren't arriving with Betts, were you? You
No,
were
we were in separate vehicles.
separate vehicles.
Correct.
eventually, after processing the vehicle, and photographing, and all those types of things, after everything else is done, now you go to, at that point, you go to locate my client.
Yes, sir.
Did, excuse me, did someone lead you to the room he was in, or did you kind of find it yourself?
Somebody had led me back there.
And I believe in the video that you testified that you seen about the process, you walked into the interview room, and you were with two other, with another ranger.
Yes, sir. Yes, sir.
And with the other person was who?
Deputy Arevalo or Arevalo, I'm not sure. His last name.
Now, do you recall whether, when you get to the interview room, whether there's a deputy stationed outside of it?
I do.
You don't remember that deputy? Do you know him?
I don't remember who that was, no, sir.
Did you inquire of anyone before you went into the room, whether or not anything about my client's condition? Did you talk to anybody about his condition?
I don't recall that, no.
Were you ever made aware that he had been placed in another interview room and had to be moved to a second room?
I don't recall that either, no.
Now, you've been a certified peace officer for how many years?
Since 2006.
2006. You're familiar with the booking process, right?
Yes, sir.
Person arrested for crime. They are booked in to the jail, and normally they will go see a neutral magistrate, correct?
Correct.
It's fair to say that once that person's in custody, they don't decide where they sit at or where they're placed at. It's the deputies or persons that operate the jail, they make that determination, correct?
That's correct.
So if they put you in a room, you pretty much stay in that room until you're removed by staff, correct?
Correct.
And if it's a situation where you want to have a drink of water, you don't get that drink of water unless the staff allows you to do it or bring it, correct?
I've never worked in a jail, so I couldn't answer that, but I would say probably so.
Probably so. You know something about the magistration process, correct? Do you know anything about the certified officer? You know about the magistration process?
Yes, sir.
Correct?
Yes, sir.
The magistration process is with a judge.
Yes, sir.
The magistrate judge will actually go over the rights of the person that booked it, correct?
Correct.
Now, before you went into that room, started this interview with my client, or that process, did you inquire of anyone in the jail staff, or the officer that was outside the door, whether my client had seen the judge, had been magistrated by him?
I don't recall that conversation taking place now.
Did you check to see whether he had been magistrated?
Yes, he was.
No, sir.
It would be fair to say that if he had been magistrated by the prior to your, it could be a situation where some decisions could be made between him and the magistrate that you didn't know about.
And Judge, that's going to call for speculation.
But you never inquired, correct?
Correct.
Now, in the room, my client's in the room, in the room, right?
Correct.
At that point, do you have any idea as to how long, how many hours he has been in the interview room?
I would say I had an idea, but I don't know exactly how long he had been in there.
Did you ask anyone? to that deputy in the front column of the thing.
No, I don't recall asking that question.
So we get into the interview room, and to recall you or anyone else asked my client questions, say, are you under the influence of anything? Ever remember asking any questions like that?
I believe it was myself that asked him if he needed anything to eat or drink, but I don't recall asking anything about him being under the influence, no.
So the answer to the question is no.
No.
In terms of a statement or trying to get a statement from some person, would it make a difference to you if that person appeared to be or was under the influence of something like, say, maybe drugs or alcohol? Would it make a difference to you?
On whether or not,
You took a statement from him,
I would still make a statement, yes.
even if he was under the influence of drugs or alcohol?
Yes.
Now, in part of your training as a police officer, you're trained in the method of taking statements, correct?
Correct.
I got to do it.
Taking witness statements, correct?
Correct.
And also taking statements of a person that could be
This
accused
guy
of
can,
a crime, correct?
the longer he talks, the better the
And as part of your
statement.
training, you're trained, you can correct me if I'm wrong, that if a person's under the influence of drugs or alcohol, you still try to take a statement.
So then each individual officer can make that determination on their own.
I'm about
At that
ready
point in
to
time.
just scream at the guy. I wish I had
Definitely
this
determine that a
down.
person is under the influence of anything.
Action.
You could ask him.
I don't want to blow your eardrums out. I can do.
So in this case, my client's case, you don't read the rank, correct?
I do not know, sir.
Okay. That was that assigned to read prayer test, or did that something that you all agreed upon before you went into the room?
So Ranger Pettis was going to initiate the interview, so Ranger Pettis was going to read the Miranda.
So
I already
one read, correct?
Correct.
watched.
Uh,
I'm already at 1.5. Here's
and
2.
in terms of reading from the card,
175.
yeah, I'm guessing it wasn't like it didn't take him 5 minutes to do it.
I'm at
Yeah, I can read it.
175, y'all.
Correct.
I've never done that.
Less than a minute, probably.
Maybe so.
It's a 2.
So as it read, it's fair to say there's not any explanation of anything. If you read, you find it, it was read, you got an indication, it goes to the next line. Is that what happened in this case?
I have to watch the interview again, see exactly how it was read and how he responded.
That's the highest.
Yes, very easy to read. Ranger Pettis, you testified during cross-examination just now that the vehicle that Bradford was traveling in, that red GMC, was first spotted about 5:30 p.m. according to the report on that day.
Correct.
I think shortly thereafter the traffic stop occurred.
Yes, sir.
From what the jury seen in that video of the interview, you know, it's recorded, you've seen. He was entered into that room at approximately 7:40, 7:50 in the PM, right?
I don't recall the timestamp of that.
If that's the time that you would have any reason to doubt.
No.
Okay, so
too fast.
between the hours of 5 and 7, we can make the extrapolation that he traveled from there to that room. Maybe he was in another room before, no, right? By the time that investigators, yourself included, come into the room, it's about 11:50 in the PM. So if that's the time step on the video, no reason to doubt it.
That's the timestamp.
Okay, so we're looking at from vehicle being spotted at 5:30 to 11:50, about a 6-hour period.
Correct.
No reason to doubt that.
No, sir.
Oh,
Okay, so we know that he was in custody for about 6 hours prior to the interrogation.
Yes, sir.
Okay. Ranger Peters, you were asked questions at length by defense during cross-examination regarding the booking process, magistration, if the defendant had been taken before a magistrate, things like that. You told us you're a peace officer, correct?
Correct.
And you've been a peace officer since 2006.
Correct.
So you are familiar with the duties and responsibilities of peace officers according to the Code of Criminal Procedure.
Correct.
Okay, so let's talk about the duties of a peace
Y'all
officer
wanna go
when a
to
person in
Gallic
custody
Ball
has to be
once?
taken before a magistrate. What do you know about that?
You want
So
to
the
watch
this
Alex
person's
Baldwin?
arrested without
We already did it.
the way it's worded is unnecessary delay.
Longer.
They have to be taken before a magistrate, but it can't be any longer than 48 hours.
Okay, was it anywhere close to 48 hours in this case?
No, sir.
Now let's talk about unreasonable delay. Remind us, Ranger Peters, why there was a delay in this case.
So if you recall, we relocated to the sheriff's office to process Mr. Tarnava's vehicle prior to conducting the interview with him. So the only delay that was incurred was during the time that we were processing the vehicle.
And why is it important for an investigator to do those things prior to engaging with a suspect?
So I didn't make the decision to go immediately to the interview with Mr. Tarnava because I wanted firsthand knowledge of any evidence that was located inside of his vehicle prior to going into that interview with him.
Okay.
I'm doing
Another
my
question.
job.
My last series of questions, I guess, Ranger Peters, is intoxication. Defense counsel was asking you about whether or not Mr. Tarnava had been intoxicated. While you were in the room with him, did you perceive any signs of intoxication while he was answering questions?
No, I didn't.
Was he able to coherently and intelligently respond to any questions that were asked of him?
Yes, he was.
Was he giving off any signs that he might be slurring his words or not understanding what was being spoken?
No, he wasn't.
Thank you, Ranger. No further questions.
Oh, God. Here we go.
Any further, counsel?
So you wouldn't suggest, prosecution, 48 hours. So are you basically saying that, keep someone locked up in a room 48 hours? That's reasonable? So the 48 hours, that's the maximum time.
That's the maximum, yes.
So you're not suggesting that, we'll be fair, well, we won't keep them 48?
I'm sorry,
We won't keep them 48, we'll keep them 24 hours in a small room locked up, right? Is that reasonable?
To keep him 24 hours
24 hours.
without reason? No, I wouldn't say that's reasonable.
And the room is not large, right?
No.
And you testified, you never questioned or even inquired to whether or not he was in another room, a separate room, before he was placed in the room that you interviewed, right?
Correct.
How about it?
No further questions.
All right, Ranger, take care of yourself. Stay well. Next witness.
Your Honor, the Senate take a rest.
I'd like to make a motion, I'd like to.
You got to take a morning break, ladies and gentlemen. All right, fully agree?
Y'all. Oh, skim. Y'all. Oh, I got
All right, see everybody, please.
I like
Ladies and gentlemen, I apologize for the delay. State your rest of your case. Defense, do you wish to give an opening statement?
No, we wait.
All right, call your first witness then, sir.
Call me, Dr. John.
Can you hear this? It's called breaking through. The next one's falling for. Funk on. We need some of the funk right now. Heaven's Instruments. And spiritual guidance. He needs it. Sorry, my friend I just got a notification from it was in a car wreck. I'm going to go ahead and get this going.
So,
I'm going to mute my.
Okay, and ladies and gentlemen, as you'll notice, the doctor is back in North Texas. He's going to offer some testimony. The defense is calling him as a witness, and Mr. Tarnava has agreed that we can do it by Zoom. So that's the only kind of situation where we can do that because you have a right to confront any witnesses against you. But they've been kind enough to agree to be able to do it by Zoom to save the doctor a flight back here for some testimony that the defense wanted to elicit. Okay, just so you know where we are. All right, doctor, can you hear me? It's the judge.
Yes, sir. I can hear you.
All right, nice to see you again. Remember that you're still under oath, okay, sir?
Yes, sir.
All right, thank you, sir. Go ahead, Mr. Cornelius.
Doctor, can you hear me okay?
Yes, sir. I can.
And you're the same Dr. Sedillo that testified on yesterday, correct?
That is correct.
I I just want to ask a few questions of you, because on yesterday, you, during your testimony, you spoke about procedures that you used to come up with conclusions that you made about the items, the fragments that you testified about, correct?
Yes, sir.
Okay. Now, there was a question that I asked you on yesterday with reference to your examination of these items, these bones, and you asked a question as to whether or not, as a part of the procedures that you perform, whether you're taking X-rays of these items. You know that?
Yeah, I believe you had asked, if I remember correctly, you had asked what the typical procedures were that we would do. And I had said something to the effect of providing a general inventory, collecting photographs, and collecting X-rays. I think that was something that I offered.
Correct. Okay. And I think it could have been on a follow-up that there were some testimony by you about whether or not you had X-rayed these items, correct?
Correct.
And do you recall whether you indicated in the affirmative that may have been done or was done?
I believe that I did say that I had collected them, which is typically what we were doing at that point.
Now, since that time, have you have an opportunity, or did you have an opportunity to go back and review files to make any determination whether that was done or not?
Yes, sir, I did.
Okay. Upon reviewing, again, your files, were there any the testimony that you gave on yesterday with reference to X-rays, was that testimony correct?
That was not correct, no.
And could you just tell what did you do, how did you make that determination that the testimony that you gave on yesterday wasn't correct?
Basically, what I realized on my way home was that there were no X-ray images saved in my review folder that I brought with me. And so I was concerned about potentially not releasing them for discovery or not actually having X-rays, because we didn't, at that point in Denton, we didn't always X-ray cases. We did on most of them. And so as soon as I got home, or on the way, I stopped and looked in my folder. And then I got home and logged in remotely to check the electronic folder, and there were no X-rays in our case folder or in the discovery folder for this case. And as soon as I got into the lab this morning, I logged into our X-ray server, and there were no cases there. So at that point, I realized that there are no actual X-rays of this material.
And based on your review, and when you realize that you had made a mistake, did you notify anybody?
My girlfriend.
Immediately notified my immediate supervisor and the head of our legal training person here at the center, and told them what had happened and got some advice on how to proceed.
I'll pass it.
Dr. Cervello,
Yes, sir.
After speaking to your supervisor and the other individuals there at the University of North Texas, what did you do with the information that you had testified incorrect?
As soon as I was done talking with them, I drafted a letter to send to your office just to inform you of the mistake that I had made, because I didn't want to sit on this. I understand the importance of getting it to you.
Yes, doctor, we appreciate that. And about how much longer?
He had a 7-way bypass. That's 5 in the heart and each artery in the neck. The right side of his heart was 100% blocked. The left side was 95% blocked. And he's, let's see, he's late 70s. He made it through surgery. He's still in very considerable risk, but he survived a 13+ hour surgery. Thank you for asking.
Or was it after you sent that we contacted you to let you know to appear by Zoom?
Within a couple of minutes, I got the first email.
All right. Now, in regard to the X-rays in this case, why would you not have taken X-rays in a case like this?
So generally, when we're looking at burn material, we're looking for there's more than we have here. We had a limited amount of fragments. I think probably less than 30 small pieces of bone. There's not a lot of material stuck to it. It's fairly clean. It's easily recognized as bone. And so there's really no suspicion of it being anything else. Often when we have thermally damaged bone, there'll be a large mass of stuff that comes in, and we have to separate out what are bone fragments, what are pieces of wood, what are pieces of tire, foam, all the other kinds of debris that might be present with burn material. And that wasn't really an issue here. And then we usually use it to search for things that we don't expect to be present. So it really, given what what we were presented with in this case, I'm not surprised that I didn't X-ray it, because it was very clear with what I had.
All right. And you testified yesterday that your determination of human versus non-human bone fragments is largely the result of observations, correct?
That is correct.
All right. And I think it's fair to say you made a mistake in believing that you've taken X-rays.
That is definitely a fair assessment.
All right. However, does the lack of X-rays in any way change your opinion about the nature of the bone fragments we discussed yesterday?
No, it does not.
That's what it's your.
That's this follow up. And Doctor, you remember on yesterday that I even asked you about whether or not a radiologist looked at these bones, correct? Do you remember?
I remember, I thought you asked me if I look at it like a radiologist. That's how I interpreted the question yesterday. I'm not a radiologist.
Oh, I'm sorry. You're not a radiologist.
No.
Now, you testified that in some cases, items would be X-rayed, correct?
This is correct, yeah.
Okay. And when the X-ray, you do an X-ray on it, are you looking for certain things on that X-ray that will help you, say, in the decision-making process?
You broke up a little bit. So you're talking about cases such as this one when we're dealing with thermally damaged bone?
Yes.
Because it's thermally damaged bone like this, and again, it's the amount of material that you receive varies from case to case. But often we get large bags of material, and it'll be a mixture of fragmented bone and everything else that could potentially come out of a fire scene. And so we have to, before we can really say anything about the bone fragments, we've got to make sure we isolate those from everything else and sort into different materials. And so we will use that because bone is relatively dense, and so it's going to show up brighter, for lack of a better term, on an X-ray than something that's not as dense like wood or foam. You know, rocks are dense, and so they might show up more dense on an X-ray. And then we also look for suspicious metal fragments. So often on burn cases, you're looking to see if there's potentially something that could be a projectile that you could recover. And so that's, on burn material, that's typically how we use X-rays. Does that answer your question?
Yes, partially. Let me ask you this question. In terms of, say, human bone, or notwithstanding a person's, say, race, are all human bones in terms of, are they all similar, notwithstanding which part of the world you're in, all human bones technically the same types of things in all human bones, or in uniform?
Are you asking if the skeleton is generally the same across all people?
Correct.
I mean, in general, there's variability, but we all have roughly the same parts. You know, some people have extra little bones that might form in tendons, or extra little bones that might form in the cinctures of their skulls. But, you know, the shapes might be slightly different from person to person, but in general, we all have essentially the same major parts.
The parts, but things like density, how dense they are, and when you look at this.
Well, that's going to be something that varies from person to person as well. You know, your age can affect your bone density, the sex of an individual might have an effect on it. General health like that. That's something that's very, very broad. You know, someone that's very old and osteoporotic, or they're not going to have bones quite as dense as someone that's younger and has healthier bone. But that's part of that variability that you look at, but it's still recognizable as bone. So
in a case you said where there's some thermal damage to a something that you consider bone, so you would just rule out the X-rays and always not X-ray them, or would it vary just based on the situation?
The main question on this, there wasn't really any doubt that what I was looking at was bone. The question was, is this human bone or non-human bone? And that is a process that involves, gross examination and examination under a little bit of magnification, like we talked about yesterday. Shooting an X-ray of those bone fragments really wouldn't have given me any more information as far as is it human or not.
Now, when you look at them through a microscope, I know there's some microscopes that you're allowed to take photographs of what you're looking at.
Mm-hmm.
Was that the type of microscope that you were using?
No, I didn't use a microscope on these. I just used we have a lamp on our workbench where we do all of our analyses. Each of our workbenches has a lamp on a long arm that has a magnifying glass in it, and then there's a separate handheld magnifying glass that we can use to look at detailed stuff. And those are the kind of items that I use.
So it wasn't a microscope, just like a looking glass.
No, gross, looking glass, gross observation, and low magnification under a looking glass or under a magnifying glass.
All right, thank you, doctor. Stay well.
Thank you, sir.
Gotta turn that thing off.
Yeah. Thank you, Deputy.
All right, next witness, please.
Your Honor, this time we just rest.
Stay rest and close session.
Close.
We close.
Fine.
And we have a motion.
Whoa, we're closing?
Just take it in the hallway. You don't even have to go back, unless you really need to go back to the room.
All right, well, Jerry.
Oh my God. Is it done? Are we done? Are we done? Does that mean that we're going to go to closing arguments?
Appointed attorney to advise him prior to and during any questioning or
Suspicion based
He threw her in the back.
or taken into consideration for settled out the phone, smart
Closing argument.
desire to use the same.
He threw her in the back. He drove her home. He dumped her body on a burn pit,
This is the best part.
and he burnt her. He used motor oil as the accelerant,
Ooh.
and he burnt her until all that was left were bones that were indistinguishable from the animal bones around them, and two charred human bone fragments that Dr. Cervello was able to identify. That's what happened in this case.
That's a hot burn.
That's why we're here. There's been a lot of talk about the investigation, about the other things going on around this case, but that's why we're here. So I'd like to talk to you a little bit about the law in this case and some of the more tricky elements of this jury charge. After I'm done, Mr. Cox and Ms. Garza will speak to you. And then finally, Mr. Jordan will give you the last word in this case. But I'd like to talk about this charge. And one thing really quickly, in regards to that confession, there are a number of discs here that contain pieces of that confession. You saw, because of the error that the state made, it was our fault, that the Miranda warning had been excised unintentionally from that original confession. We now have a complete version. The only things removed from it are things that are muted for evidentiary purposes, but states 103 is going to be the one to ask for. If y'all want to watch the confession, if you want to see anything from the defendant's statement, ask for states 103. That'll be the complete thing. Now, I'd like first to talk to you about the on or about language. And the way the law is in the state of Texas, on or about can mean any time anterior to the presentment of the indictment, which means before the indictment is signed by the grand jury, back to the beginning of the statute of limitations. There is no statute of limitations for murder. So, as long as the state proves that this offense took place before September 7th, 2022, the on or about language is legally satisfied. We've done more than that. We've proved to you that this happened in late April of 2021, on or about April 26th. There's a little bit of disagreement. Some of the civilian witnesses who saw it happen aren't entirely sure, 27th, 28th, those exact days, and law enforcement wasn't involved until a month later. So there's a little bit of wiggle room, but we proved that it happened on or about April 26th of 2020. The other thing I'd like to talk to you about is these two sections about the voluntariness of the confession and the legality of the stop. So you received instructions that an officer must have a reasonable suspicion in order to pull somebody over for a traffic stop. And that's right here in your jury charge. There's been a lot going back and forth about pretext stops, about maybe a briefing that did take place earlier that day, whether officers were looking for a reason to pull the defendant over. And I'll tell you, they were. All of the testimony from the stand says they were. But this instruction tells you that the question is an objective one. If an officer has a valid reason to make a traffic stop, then the stop is valid, no matter what the underlying reasons are. And in this case, they stopped the defendant for failing to display a rear license plate. It was a valid traffic stop. And it was a valid arrest. Which takes us to the question of the confession. Now, there are three circumstances that the jury instructions talk about. They talk about whether the defendant was in custody, whether the defendant was Mirandized, and whether the statement was voluntary. Now, I will tell you, the first question is, there is no question. He was in custody. He was under arrest. He was at the sheriff's office. He was not free to leave. This defendant was in custody when that interview took place. He was also Mirandized, and this jury instruction gives you the 5 questions that have to be asked to satisfy Miranda. Now, those questions don't have to be asked verbatim, but they have to ask everything in those questions in order for Miranda to be satisfied, and you can watch it on the video. You already have. The defendant was Mirandized before he said anything of substance. So the only question that's left is the third one, and that's whether or not the defendant voluntarily waived his Miranda rights. Now, the question about whether the defendant voluntarily waived his Miranda rights is not a question of how long he was detained prior to being given those Miranda rights. It's not a question of whether the police conducted other searches while he was waiting. We agree in this case, there is no dispute that 6 hours went by, a little bit more than that, between when the defendant was pulled over and when he was Mirandized. That's not the question. The question is whether he was capable of voluntarily waiving his Miranda rights when the interview took place.
And he was.
And you determine that by looking at the video and how the defendant was doing and all the evidence you have. You look and see if the person you saw on the video was incapable of waiving his rights or the person was capable of it, whether he was all there, whether he was lucid, talkative, coherent, whether he remembered what happened as he talked, whether he showed emotion but restrained his emotion, whether he was in control of what he was doing and what he was saying when he waived those rights. Did you see a person who was entirely broken, unable to waive his rights and voluntarily make those statements? Or did you see someone who just woke up from a nap? Now, if you find that the confession was involuntary, if you do find that he was not able to voluntarily waive his rights, that's not the end of the case. The result of you finding the confession involuntary would be that you need to disregard everything that was said in that statement and any evidence that was obtained because of the statement. Now, in this case, there was no evidence obtained because of the statement. As you've heard over and over again, all of the evidence in this case that the Rangers collected, all of the witness statements, all of the physical evidence, every bit of that evidence was obtained prior to them conducting that interview. So, if you find the confession was involuntary and you decide to disregard it, you still consider all of the evidence that's before you in this case. I believe that that is all of the things I'd like to talk to you about with regard to the charge. I'd like to thank you for your patience this week, and thank you.
For the patience of listening to that Yahoo over there. Okay, that's the first time I've heard from her.
Good afternoon, ladies and gentlemen. Thank you for your patience, for your attentiveness, and for
Putting
paying
up with
close
my
attention
partner.
throughout this entire process. I know it's been a long couple of days, and I know you have been paying attention, writing notes, focusing on the witnesses that have come
Quit
forward
schmoozing us
and
and get to the damn
testified.
point.
This is almost the end of the case. This is the time where the judge will hand you the case and where he will hand you the road. You all will become judges. And what that means is that every single person that sat on this chair, you will now be the judge of their credibility. You will decide if their testimony was credible. You will decide if they were truthful, and you will decide if the weight of the evidence was credible. So when the judge hands you the case, you will now become the judge.
I so want to be on the jury. I know that's bad.
You will judge the credibility of all the witnesses that came in and testified, including all the law enforcement agents that came in and testified, including all of their actions or lack of their actions. You alone individually will be the judges of their actions. With that said, when you go and you deliberate, you will be handed the charge of the court, as the state mentioned. And so I'm going to go over certain portions of that with you, highlighting some of the portions that I would like you to focus on.
Yeah, focus on what I tell you to focus on, not what they want.
And as the state focused on, I'm going to also be focusing on the stop. He focused on the reasonable suspicion of the stop.
I got her. She's just almost as
Law
bad as
enforcement,
he is.
they talked a lot about that there was reasonable suspicion of the stop. When you go to the back, you're going to have the definition of the reasonable suspicion. The judge read everything here. He read everything that you're going to have in order to make a decision, in order to render a verdict. You're going to have everything here. All the law, you're going to have it with you. You're going to be able to tear it apart, pick it apart, and be able to make a decision. The state of Texas earlier stated that there was reasonable suspicion to stop the vehicle. However, if you go back and you listen, I know that you were listening. If you go back and you reflect on the statement made by Deputy Garza and other deputies, when they went to the briefing, Deputy Garza clearly testified that they were going to find a reason to stop Mr. Tarnava. They never said that there was probable cause. When Mr. Tarnava was driving off of I-35, and they were at that briefing, he clearly testified and he said they were going to find a way to stop him. They never said that there was probable cause. They were going to find a way to stop him. So when you go back and you go to that section where it states,
They have
under the
probable
laws of the
cause.
state
They're
of
going to
Texas and
find
the
a way.
United States, before a police may stop a moving vehicle for a traffic offense, the officer must have a reasonable suspicion based on articulable facts to believe that the driver has committed some offense against the traffic laws of the state of Texas. Remember what Officer Garza said. They were going to find a reason to stop. Did they create probable cause? Did they make it up? Because in that briefing, they said they were going to find some reason to stop him. That's what he testified to.
At least
I also want to talk about,
attorney is not talking right now.
there was a lot of mention about the interrogation, about Mr. Tarnava's interrogation and his statement. And it is true, there has to be 3 prongs that need to be satisfied. And one of them is the statement, when the statement is given, it has to be under custodial interrogation. And I think we can all agree that Mr. Tarnava was in custodial interrogation. That's the first one. The second one, prior to making such oral statements, the accused was not given the following warnings by the person to whom the statement is made. That means that.
So if I got up and I was the state to put in my last word, I would argue that number one, there was a cause to pull him over. He had no license plate. And under Texas law, that's probable cause to pull you over. They didn't have to create it. They didn't sneak up to the vehicle while it was parked at a stoplight and rip the license plate off and then go, we can pull you over. Biatch, please.
Was he given his Miranda rights? We had that whole issue where they had to get another DVD made so that you guys could hear that the Miranda warnings were given to Mr. Tarnava. So he was given his Miranda warnings. That's the second prong. The third prong is where the state of Texas and I disagree a little bit. It states, and the defendant did not knowingly, intelligently, and voluntarily waive such rights if they were given. The state of Texas position is that Mr. Tarnava freely and voluntarily waived those rights. However, it goes on and it states a defendant's statements may be considered involuntarily when there is overreaching in the form of official coercive conduct by the person doing the questioning of such a nature that any statement obtained thereby was unlikely to have been the product of an essentially free and unconstrained choice by its maker.
Y'all, let me ask you something. Is that hairstyle about 10 years outdated?
So Mr. Cox focused a lot on where Mr. Tarnava was during the entire time of the interrogation. He was in 2 separate rooms. We really don't even know how long he was in that other room. We think he was in the room probably an hour and a half, maybe a little longer. And in the video that you saw, we got it down to maybe 4 hours. So 4 hours by himself in handcuffs, and in the other room, maybe an hour, hour and a half. So total, maybe 6 hours without anybody there. We do know that there's an officer outside. So they want to claim that he's comfortable because he's asleep. Well, he has nothing else to do. He's a big guy sitting in that chair. I don't think that's comfortable. He has no.
Oh my God, you are so freaking overreaching. They can detain you up to 48 hours. He was not put in a room with no table, no chair, which is considered a holding cell.
Nothing else to do but to sleep. He can't leave. He has an armed guard outside. He can't leave. He can't use the phone. He can't get any water. He can't get anything to eat. So he's not free to leave. He's been there. They don't know if he has any medical issues. He doesn't know if he has any medical conditions. He's in another room first. They transport him to the other room while they're searching his home, searching the vehicle. Then they finally come in.
They can do that.
To the law enforcement agencies, they feel that that's okay. It's not. So you have over 6 hours of him being in that room, unable to leave, unable to use the phone. He's not comfortable. The only thing that he can do is sleep. They make it a point to say that he's okay because he's sleeping and he wakes up. He has nothing else to do but to sleep. So when you look at this definition, the fact that he is in there for these 6 hours and then they come in and they start asking him questions, you could analyze that And it could be
Did they say
that
46 hours?
the questioning of such a nature is obtained, thereby was unlikely to have been a product of an essentially free and unconstrained choice by its maker, because of the amount of time that he was in there, and he was not free to leave. It was not voluntary, because the amount of time that he was in there.
Wait, I need to get a baby cry.
You are instructed that unless you believe from the evidence beyond a reasonable doubt that any statement introduced into evidence was freely and voluntarily made by the defendant without compulsion or persuasion, or if you have any reasonable doubt thereof, you shall not consider such statement for any purpose nor any evidence obtained as a result thereof. Thank you.
That's what I need.
May it please the court, counsel for the state, members of the jury. This part of the trial is referred to as summation or closing arguments. This is where the lawyers kind of highlight what we felt that the evidence showed. As the judge indicated, that what the lawyers say is not the evidence. At first, we'd like to thank you for your being here throughout this trial and being attentive to everything that has happened in this trial thus far. Now, as the defense attorneys, we're placed in a situation where the state had spoken to you earlier, and then when we're seated and we can't say anything else, we'll come again and we'll talk to you. Now, so we have to kind of respond to what they said thus far and kind of anticipate what they're going to say when we're seated and we can't come back and say anything else to you. Sometimes they'll come and they'll point a finger at me as the accused and maybe hit on the fist on the table and tell you this is a clear case. That everything, the only thing you need to do is go back into the jury room, come back with a swift verdict of guilty. In that their interest is just providing facts and justice.
Oh my God, this is brutal.
The problem is that your job is to review,
Look
all
at
the
the judge.
consider what they brought,
I can't do this.
and also you can think that's lacking. The burden never shifts. The burden never shifts. Their responsibility to provide the evidence and prove every element of this case beyond and to the exclusion of every reasonable doubt. And if they fail to do that, it's not a situation where you have to grapple with that. If they fail to do it, your verdict has to be one of
Poor judge.
not guilty. That's all.
I bet the judge absolutely hates having this guy in
No.
the courtroom.
As I mentioned already, the prosecution had, well, you want to look at the charge, take it back with you, and I think the words that the prosecution used, that this is a tricky charge. And this is a law that's given to you by the judge. Now, they refer to it as a tricky charge. Why? Because it's the law. And if something doesn't go along with their theory or their way it should go, then
You
the law
don't have enough straw to
tricky.
even grasp one.
they mentioned already about the investigation. The defense spent a lot of time on the investigation, talking about the way the case was investigated. The ends of these cases, any trial, doesn't justify the means. So it's not a situation where you can investigate a case in any kind of way you want to, and at the end of the day, as long as you convict somebody, all's well. We anticipate, they're going to show you photographs. They're going to probably put the interview back on the screen, actually to look at it in terms of their positioning on the case. But the investigation is important too. And there were witnesses. Some eyewitnesses that were at distances where they indicated that they saw some things and didn't see other things. Some witnesses that testified that they were under influence. Meth. That's all part of the case. You can't separate things and just say, well, no, it doesn't matter. You gotta get it all. At the inception of this investigation, there was an issue. One of the issues was that not one of the eyewitnesses that took the stand ever said that, well, I saw something and I reported. Not one. Secondly, with reference to the investigation, there was kind of a rush to do it. Why? Because at various inception, you have a situation where the two rangers that testified, Ranger Peters and Ranger Perez, give different versions of what happened at a briefing that happened the same day that my client was stopped and arrested. These are officers, not only officers, rangers, all kinds of experience. They're on witnessing and they're looking at their notes, their case file, their cases, their investigation. And almost every time a question was asked, that wasn't asked by the prosecution, they didn't recall.
Oh, yeah.
What time did you leave the location? I don't recall. What time did you get to the location? I don't recall. She's right in your notes. I don't recall. Look at your notes. Oh, it's not here. I don't recall. Say ask a question? Oh, sure. Something to their event? Oh, say it.
This is what I royally think about this man.
Anything else? They didn't call. The problem, in the same conversation, well, no, it's not important. Everything in the case is important. We ask questions about the evidence law. They don't recall. Did you give, in that briefing, the briefing? They don't recall. They don't recall how long it was. They don't recall, except for maybe 1 or 2 hours, how many were there. They don't recall what instructions were given to them. They don't recall. They go out and they claim that they execute search warrants. They don't know how long it took them. Not sure what time they get to the next locations. They don't recall. Those things are important. And why? Because when you look at the instructions, and there's issues in terms of whether or not a statement that was taken, and whether that process was a process that someone may have overreached, the time frame is important. The lead rangers, they don't ask whether kind of been agitated. They don't ask how long you've been in the room, whether that room was air conditioned or not, whether it was hot. They don't ask. I submit to you because no, that's not important. What's important is to get a statement. Now that's important, to get a statement. The ranger on the stand, under oath, is asking you to say, well, it doesn't matter because the person's under the influence or not. Drug, alcohol, it doesn't matter. Why? We need to say it. So what did they go out and they do what? They never come to testimony from rangers. The other rangers, they have people to help. Have folks that go and take the evidence and also take the question, give me a statement. To have someone sit for hours and hours, and we don't know what those conditions were, mostly. That's the thing stage. It's part of it to kind of wear a person down so they're more susceptible to giving a statement. The standard is, and the standard will always be, proof beyond a reasonable doubt. Proof beyond a reasonable doubt. This morning we had the doctor that talked about the x-rays, and he mentioned that he testified under oath about his observations, reference x-rays that were part of this decision-making process, and he realized that he had made a mistake.
Oh my God, y'all.
People make mistakes.
We're at 1.75 on this man.
Make mistakes.
Fed up.
I
You
don't know
get
exactly
defeated.
what the state is going to say to you once you they may wheel the barrels back and talk about those. What you know is that this case, based on the evidence, was targeted. And part of that targeting was to build the evidence against my client.
For a man that has all those notes there, he is rambling. Oh, I just want to speed this up.
Officer Carter, I believe,
Pardon.
was at that briefing. His testimony was that he was told that they needed to find a reason to stop the people. It's not my words. Those are his words. I submit to you that in terms of the statement that my client gave, that there were issues about the timing of it, and the officer's repeated responses. I don't recall. I submit to you that statement, based on the law, the charge, in the instructions, you disregard. The state tells you that, well, even if you disregard it, there was nothing, no other evidence that was gathered based on that, or even based on that stop. State exhibit number 25 and 26 appears to be some type of handout that comes from that interrogation. I submit to you that when you consider all the evidence, the lack of evidence in the way that evidence was actually gathered, And even if it's a pound on his desk and he points at my client, that no need for it, that's just all those issues. There's a verdict. I'm not guilty. Thank you very much.
Mr. Jordan,
Victim's court.
please.
Opposing counsel. Good afternoon, ladies and gentlemen. At the very beginning of this trial, during opening statements, I told you that this case, in a nutshell, would be about three things. And those three things remain as true then as they do now. I told you that this case was about him shooting her and killing her, burning the remains, and him being guilty. And all of the evidence in this case has proved that beyond a reasonable doubt. All of the elements that we discussed ever since jury selection have been proven to you beyond a reasonable doubt. Back in opening statement, the state also gave you a sort of roadmap of everything that we expected you to see throughout the course of this trial. I told you the witnesses that would come to talk to you, in what order they would come to talk to you, and all of those things have come true. All of the promises that the state made to you have come true. This case has been proven beyond a reasonable doubt, ladies and gentlemen. You heard from the victim's daughter, Marisol Klingelhofer's daughter, right? And she told you when she made the report of her mom being missing. You heard from the two officers who started receiving those anonymous informants, as well as the witnesses that came forward regarding the disappearance of Marisol Klingelhofer and how she would never be found. You heard about the traffic stop. You heard from the rangers. You heard from the anthropologists that confirmed those two bones that I told you they found were human remains, where the witnesses say they would be found. And you also heard from the defendant himself, like I told you would, throughout the course of that interrogation. Beyond a reasonable doubt, ladies and gentlemen. This case, since the very beginning, has been about those three things, right? I agree with Mr. Cox to this point, and I told you this even since jury selection, right? Our duty as prosecutors is to see that justice is done, right? And we brought everything to you that we could to show you beyond a reasonable doubt exactly what happened in this case. And the reason I say everything that we could is because obviously there were things that we could not. Things like this firearm, right? And we know what happened to that firearm. Things like DNA from that blood, that presumed blood that was found in the back seat of that GMC, in that back trunk area of that red GMC, right? But let me remind you all the way back to jury selection when we talked about who decides when, how, and where a crime takes place, right? Do you guys remember that? The person committing the crime decides, right? Who decided to commit this crime? Andres Tarnava. Who did away with that gun? Andres Tarnava. Who did away with that body? Andres Tarnava.
Tarnava.
Andres Tarnava, the same person who hoped that by his brutality and by his intimidation, no witnesses would come forward and talk about the crime that he kept bragging about for days after he had committed it because he had zero remorse for what he had done. We brought to you the barrels, ladies and gentlemen, because I think it's important. If you recall, when Ruben was up there testifying, the threats that Andres Tarnava was saying to him was that he had cut her up and he better not say anything or he would kill him, right? That's his words to Ruben. We brought you the barrels so you can get a size comparison, right? So you can see them and see their size.
That was rough.
And you tell me,
They had the barrel.
when you go back there and deliberate, if you believe that a whole body could be fit in those barrels and then burnt so severely that only two bones could be recovered. He was making very credible threats to those witnesses. Now, regarding those witnesses, ladies and gentlemen, we talked about that too, even since jury selection.
Credible
We
threat.
talked about perfect witnesses, right? We're not saying that the witnesses that came forward to testify for you are perfect people. We're not. And the state of Texas is not sponsoring that to you, right? We don't get to choose who sees a crime. They are the people that they are, and they are who they are. We don't get to choose because like we talked about with who chooses where and how a crime is committed, we have nothing to do with that. But we brought you those eyewitnesses so they could give you the accounting of what they saw that mid-April day in 2021. And their stories were all consistent. They were consistent to each other's. They were consistent with the eventual confession that you hear from Andres Tarnava to the T. Ruben ran away. Multiple shots. Green vehicle. 25 caliber handgun. Chrome in color. Small. It looked small in his hand. Everything is just consistent from point A to Z. Because it's the truth. You don't have to like those witnesses. We're not asking you to like them. But they were telling the truth, and that is obvious. They didn't come forward. I wish that
And
they
he threw the
had.
gun
That
in
would
the
be the right
trash,
thing
and
to
the trash
do.
was taken to the dump.
I'm not justifying why they didn't come forward, but they saw what they saw.
Feared for their lives is what
There's
they
also the
told.
matter of the voluntariness of the confession, and that was a point of debate throughout the course of the trial. It was voluntary, ladies and gentlemen. That's the point of the Miranda warning. 6 hours. It's a long time, but relatively not that long when you consider into account, like Ranger Peters told you, that it can be kept in custody for up to 48 hours before being presented to a magistrate. That's worst case scenario, right? A maximum of 48 hours, not to exceed 48 hours, right? The question is whether the delay is reasonable. And we know what they were doing. They were gathering all the evidence that they could before they talked to a suspect in a murder investigation. We want them to go into that interview room armed with facts and evidence that they can confront a person intelligently with, right?
Mm-hmm.
They weren't out there twiddling their thumbs and trying to wear down his resistance or what have you. They were gathering evidence that can go away, evidence that can spoil, right? Like bodies and things that are burnt, things that can be moved, right? So it's important. It's super important. Vehicles can be moved. Super important. Likewise, you can see in the video that the defendant spends most of those 4 hours in that interview room sleeping. He's asleep, right? When the Rangers come in, they ask him, "Are you okay?" Golden opportunity to say, "No, I'm not." They read him his Miranda warnings, one after the other after the other. He nods his head. He says, "Yes, I understand." At any point, that's the point of the Miranda warning. He can say, "I don't want to talk to you.
Look
I
at
want
the
my
judge
attorney."
paying attention.
He doesn't do that. It's voluntary, ladies and gentlemen. And even then, for about an hour, he claims that he doesn't know who Marisol is, and he's giving off this whole tale until he eventually confesses, right? There was
Then
no
blames it
degrading of his
as
ability to resist or anything along those lines. That was voluntary.
Y'all may not have seen this part, but he gets upset because she supposedly disrespected his father by taking something that belonged to him that was his father, who is now deceased and a war veteran, and therefore it pissed him off. And I went off on him.
It was a voluntary confession, ladies and gentlemen.
I was not.
He even goes as far as to give you the motive as to why he does it. It was so voluntary, in fact, that he tells you why he did it and how little lack of remorse he has for doing it. He'd do it again. He said that.
It's all about him and disrespect.
There should be no doubt in any of y'all's minds, ladies and gentlemen, as to what happened in this case. There shouldn't be. But let's go back to the subject of justice, right? And Ms. Garza told you this as well while she was up here and told you that you would go back to the deliberation room. If you recall back during opening statement, I also asked you or told you that at the end of this trial, at the point that we are now, the state of Texas would ask you to return the only true verdict in this case as supported by the facts and the evidence, right? Remember that our job to seek justice. Well, now that job actually goes on to you as you go back there to deliberate, right? The ability to do justice in this case and to arrive at a just verdict supported by all the facts and evidence is up to y'all when you go back there. We try to arm you with as much facts and evidence as we possibly can for you to make that determination fair and easy for you, right? As easy as we can make it. And all of the evidence in this case, the overwhelming amount of it, all of the corroboration between it has done that, ladies and gentlemen. So the state of Texas is going to ask you, as I said in the very beginning, to return the only true verdict in this case. And that is a verdict of guilty. We live in a society, ladies and gentlemen, of consequences, right? A cause and effect. And when you do something, you have to face the music, right? Like the saying goes, he who reaps the wind has to be prepared to reap the whirlwind. Well, now it is time for Andres Tarnava to face that whirlwind which he himself created. So find him guilty And I assure you that when you return that verdict of guilty, you will not be telling this defendant anything that he doesn't already know. Thank you for your time.
All right, ladies and gentlemen, we await your unanimous verdict. All right for the jury?
Wow. Wow. Okay. First of all, I want to do this. My mind is, that worked good. And that lawyer sounds like, I'm liking these sound effects, y'all. And we're done. Thank you. Thank you. Thank you. Okay, let's see. What happens next?
Mr. Tarnava, you wouldn't mind, sir? Could you rise with your lawyers?
Verdict in how many minutes? Okay, 3:30. 1 hour. Less than 2 hours, y'all. Verdict. How much do you want to bet it's guilty? Guilty. How much you want to bet?
Okay, have a seat, everybody, please.
We all know the verdict.
All right, ladies and gentlemen of the jury. My understanding the jury has reached unanimous verdict.
We have your honor.
Could the foreperson please hand the verdict form to the bailiff?
He's like, let's nip this.
Mr.
Not
Tarnava, you
one.
wouldn't mind, sir?
I'm
Could you rise with
tired
your
of
lawyers?
this. His attorneys were horrid. He knows he's guilty. Look at that perch lip.
This cause number 2022 CR 8637, the state of Texas versus Andres Perez Tarnava III. Verdict form reads, we, the jury, find the defendant Andres Perez Tarnava III guilty of the offense of murder as charged in the indictment, signed by the presiding juror. Does either side wish to have the jury polled?
No.
No,
All right, have a seat. Thank you. All right, ladies and gentlemen, what that means is that your service is done. So all the things that I told you about earlier about not talking and not, you can do all that if you want to, or not if you want to. I must admit, I'm going to miss you. I've kind of gotten used to you. Now, you don't have to say, Judge, we're going to miss you too. I completely understand that you want to get your belongings and get the heck out of here.
Yes,
But,
look at that lip.
I will say, not one of you were ever freaking
I don't
5
know. We're
minutes
gonna
late.
find out.
Not even 5 minutes. You never made us wait. We made you wait. You didn't do that to us. That's for darn sure. You came and you did your job. I don't think anybody ever assumed or told you anything about it being an easy job, because it's not. Now you know it. But you did your jobs. You ought to be proud of yourselves. All right. So with my thanks, with their thanks, with their thanks, with everybody's thanks, I release you from all of my prior
Not the
instructions.
defendant.
So you, like I said, you can talk to anybody, your family,
No
your friends, whatever, if you want,
kidding.
or not. That's completely up to you. Okay. Just if you're interested, what will happen now is there will be, because Mr. Tarnava has decided to go to the court for punishment, the court will not be me. It will be Judge Meza. All right. So she will do what is called a pre-sentence investigation, and they will delve into Mr. Tarnava's background. Everything he's ever done in his life basically is in a report, and then they will talk to Marisol's family and things like that, and compile this big report, and then she will decide what the appropriate thing to do with Mr. Tarnava is. Okay. So that will come from Judge Meza at a different time. Okay. All right. Just in case you guys were wondering about that. All right. So with my thanks, God bless you. Take care of yourselves. It's been a pleasure meeting you. All right. All right, for the jury. And then they will talk to Matt.
Oh, she's consoling him. Want to make sure you get something to eat, make sure you get everything you need. I will keep an eye on it. Ooh. Are y'all hearing the sound effects okay when they're talking? Oh, they're tapping him like it's going to be okay, dude. Dude, you may get life in prison or the death. The DEP. The DP. And this very well may a DP case. Oh, look at them. They're like, yeah, we so good. Let's see if there's any handshaking or any communication. I like watching what happens. Yep, there was. Okay, guys, that case is done. Oh, so I like the crickets. The bomb, or what they call the bomb ticker. The ticker. And then I can go. I have all kind of fun stuff. What's this? Y'all like, I really like the crying. That may come in very handy when Karen Reed is found innocent. There's going to be crying all over the place on that prosecution side. I said it. I'm not sorry. Okay, guys. So, Ronnie, you guys, let me know if you're not hearing these sounds because I think I've got it figured out. I know, right? I am very well could have been. No, that's tape. Yeah, toilet paper tape. They. I wonder if somebody him and while he was there busted his glasses. Looks like they've been trampled on. But they weren't like that today. They weren't like that today. So y'all, we did it. We did it. We got a case done. All right. I'm going to go relax. I appreciate y'all being here. I appreciate y'all's patience while I play with my stuff. Let's get our funk on for a minute. Yep. I'm liking this sound deck now that I got things going. It's so hard to find fun stuff that's copyright free. Okay, for the last time. For this guy anyway. I can take him off my slate for now. Bye, guys.